So with that, please, let's give a warm, my town, your town, Steamboat welcome to my good friend, Chuck Cooper.
Well, good morning, ladies and gentlemen, and Steve, thank you very, very much for that kind introduction. Nobody knows better than I do that it was too kind, but as you could tell, Steve and I have had a very special bond of friendship for many years. There is no dearer friend to me and my wife, Debbie Cooper, and I have a whole speech full of anecdotes of times when Steve pulled me out from in front of the train, the locomotives one time after another. So it's wonderful to be here with him, and it's really wonderful to be with all of you today here at the annual Freedom Conference. I want to thank the Steamboat Institute for inviting me to participate today. This has been really an inspiring event. Debbie and I have just really enjoyed it. Our spirit is renewed to see all of you and to hear the things that we've heard. I think Lynn Cheney got our event kicked off yesterday on the right foot, talking about true heroes and the heroic deeds of Madison and the other founders in winning our freedom and then protecting that freedom with our extraordinary Constitution. Unfortunately, I'm not going to be speaking about a hero today or heroic acts. My subject matter is the Obama presidency and the rule of law. Probably more aptly entitled, the Obama presidency versus the rule of law. But as Steve mentioned, it was my great privilege and honor to serve President Reagan in the Department of Justice in the Office of Legal Counsel under Attorney General Ed Meese. And one of the important responsibilities of that office is to provide legal advice to the entire executive branch, all the departments and agencies. They were essentially my clients. And since that time, I've spent the bulk of my career, I think as Steve mentioned, suing my former clients. And you really just can't possibly imagine how gratifying that is. But one of the real responsibilities of the Office of Legal Counsel is to help the President protect the prerogatives of the Office of President against encroachment by the other branches. That is, without a doubt, one of the President's most important responsibilities, but it made me a very unapologetic advocate for robust executive power. And I believe that every president has the right and the responsibility to exercise his constitutional powers to the fullest extent of Article II's limits, both to implement his own electoral mandate and to protect the office from the encroachment of the other branches. I also believe that the president has the right and the responsibility to refuse to enforce laws that he firmly believes to be unconstitutional, at least until the issue is finally resolved by the United States Supreme Court. That obligation flows from his oath of office, which is prescribed by the Constitution itself to preserve, protect, and defend the Constitution of the United States. But it's also the peculiar responsibility of the Office of Legal Counsel to counsel the President and advise him objectively and honestly on the limits of the President's powers. And it's the President's constitutional obligation, also secured again by his oath of office, to respect those limits. That's one of the President's most important but difficult things to do. Every new administration comes into office with the conceit that it has been sent to Washington to protect the American people and save the country from the misguided policies of their opponents. And a natural craving for power of those in power for more power is especially ravenous when the mission at hand is to save the country. The framers very well understood that phenomenon. They understood that men are not angels, and that ambition, therefore, must be made to counteract ambition, as Madison put it in Federalist Paper number 51. So when the framers set about establishing a system of government that was separated, the legislative, executive, and judicial branches, they equipped each branch, again, in Madison's words, with the necessary means and the personal motives to resist encroachments of the other. Article 1 of the Constitution vests in Congress all legislative powers herein granted. And Article 2 vests the executive power exclusively in the President. And once a bill becomes law, the President's constitutional responsibilities is very clear under our Constitution. He shall take care that the laws be faithfully executed. Indeed, that presidential assignment is unique, for it too is secured by his oath of office, faithfully to execute the office of President. The Take Care clause thus does not grant an Article 2 power. It imposes an Article 2 duty, a duty derived from the colonists' own very bitter experience, which George III's practice, condemned in the Declaration of Independence itself, of suspending, quote, laws of immediate and pressing importance. And the Take Care clause requires the President to execute the law as he finds it. He cannot amend it or otherwise alter it, even with Congress's statutory authorization. As the Supreme Court held in a case striking down the so-called Line Item Veto Act, there is no provision in the Constitution that authorizes the President to enact, to amend, or to repeal statutes. But our Constitution's system of checks and balances has been no match for President Barack Obama. He has violated his oath of office comprehensively, for he has done that which the Constitution forbids, and he has not done that which the Constitution requires. In that former category, President Obama has responded to Congress's refusal to act certain measures on his legislative agenda by nonetheless unilaterally imposing them through executive order and other UKZs on the American people as law. And he's made no bones about his usurpation of legislative authority. He's oftentimes openly coupled his imperious declarations with his imperious edicts with imperial declarations. I'm sure you all remember these, but let me just remind you of a few. I refuse to take no for an answer. Where Congress won't act, I will. We can't wait for an increasingly dysfunctional Congress to do its job. I will act on my own. And of course, most famously, I have a pen, I have a phone, and I can use that pen to sign executive orders. About the only claim that President Obama has not made yet is l'état c'est moi. Examples of President Obama's usurpation of congressional powers abound, but two of the more egregious instances, I think, illustrate the point very well. You may remember back in 2011, President Obama rejected the notion, as he put it, I can just suspend deportations through executive order. He acknowledged at that time in his words, there are laws on the books by Congress. And for me to simply, through executive orders, ignore those congressional mandates would not conform with my appropriate role as president. Well, duh. But that was before Congress refused his request to enact the DREAM Act. And Congress's failure to act, the Obama administration reasoned, justified its own adoption through the so-called deferred action policy, which did precisely what the DREAM Act would have done if it had been passed. exempting from deportation up to 1.75 million illegal aliens who were children when they came to the United States. The second example occurred when the Senate refused, over an extended period, to confirm President Obama's nominees to the NLRB and his nominee, Mr. Cordray, to the Consumer Finance Protection Bureau. President Obama gave all of them a recess appointment under the recess appointments power that he has under Article 2 of the Constitution, notwithstanding the fact that the Senate was at the time meeting every third day in so-called pro forma sessions. And it was therefore not in recess long enough to justify, even under long-standing executive branch interpretations, those recess appointments. President Obama declared himself unilaterally that the Senate's pro forma sessions, which was a practice that dated back over 60 years, and in which the Senate had actually enacted a bill into law, that those pro forma sessions were a nullity. So he presumed to overrule the Senate's judgment as to when it was in session and when it was not. I'm sure all of you also recall the Supreme Court rejected that power and threw those nominations, those appointments out. Now, he attempted to justify these unilateral actions in both cases on a theory of necessity occasioned by Congress's refusal to enact measures that he deemed in the interests of the American people. But his unilateral execution of those policies as law was a violent trespass on Congress's own constitutional prerogatives. No less serious an insult to our constitutional order is President Obama's repeated refusal to execute laws that have been enacted by Congress. At the top of that list stands a 2,700-page monstrosity known as Obamacare, ironically, President Obama's namesake legislative achievement. Seems like hardly a week goes by without some new announcement from this administration that it has decided to suspend or otherwise not to enforce another unambiguous black and white requirement of the Affordable Care Act. Not because the requirement is somehow believed to be unconstitutional or for some reason impossible to enforce, but simply because the perceived consequences of enforcement are not acceptable, usually not politically acceptable, to this administration. According to the Galen Institute, you'll be hearing from the Galen Institute in the next session, the tally of Obama's unilateral suspensions or amendments essentially to the Affordable Care Act now stands at about 24. I'm not going to trudge through them. I refer you to the Galen Institute's website, which keeps a running tally of these things. It's very impressive. A couple of my favorite examples, though. First, the Obama administration has twice declared that individuals with insurance policies that do not meet the law's unambiguous minimum coverage requirements may nonetheless retain their policies despite the law's clear requirements that they be eliminated by a date certain. It extended the life of those policies to 2017, very conveniently ensuring that millions of cancellation notices would not be delivered just before the 2014 elections. Another example, despite very clear language limiting tax subsidies to individuals who enroll in Obamacare on an exchange established by a state, only by a state, the IRS has issued a rule providing tax subsidies to people who enroll on a federal exchange created by the Obama administration. Well, the D.C. Circuit Court of Appeals has recently held that that violated the clear language of the statute itself. The short of it is this: President Obama has not faithfully executed the Affordable Care Act. Rather, he's treated it as a set of suggestions to be enforced or not at his pleasure. And his open and repeated refusal to enforce the Act's provisions amount to a large-scale abuse, pure and simple, of his presidential authority. Other examples of the Obama administration's disregard for the rule of law are as varied as the federal bureaucracy itself. I'm going to highlight only two for reasons that will become apparent in just a few moments. One of them I think most of you here in Colorado will be familiar with. Recalling his own youthful use of illegal drugs, the president not only has suspended federal laws prohibiting the sale and use of marijuana, he has openly encouraged violation of those laws, even going so far as to provide official guidance to banks on how to provide financial services to marijuana dealers. That is a federal felony. And in perhaps the most appalling revelation concerning the Obama administration's abuses of executive power, the IRS singled out the president's political opponents for special and unfavorable treatment under the tax code, a positively Nixonian corruption of the rule of law. Now, President Obama's abuses and usurpations cannot be dismissed as some lamentable but transient condition from which the rule of law and our country will hopefully and presumably recover once this administration has run its lawless course. That is not how the natural contest for power in Washington works. The White House will never be occupied by an angel, nor will Congress. And today's abuse of power is tomorrow's historical precedent, cited not only to claim that the earlier abuse is now some accepted part of our constitutional tradition, but to defend the latest incremental abuse that has now been assayed on top of it. If you doubt this, go read the Solicitor General's briefing in the Noel Canning case, the case in which they defended unsuccessfully, thankfully, the recess appointments that I mentioned earlier. The point is that a failure to resist President Obama's repeated serious offenses against his oath of office is not only to suffer the consequences ourselves, but to condemn future generations to suffer them as well. Nothing short of our constitutional order is at stake at this time. Well, what is Congress to do about it? What can we do about this? The truth of the matter is, unfortunately, that the framers left us very few methods for enforcing the presidential oath of office against a willfully disobedient president. They relied primarily on the remedy of the ballot box. They rejected a parliamentary system, opting instead to subject the president to the political discipline of regular and relatively frequent appeals to the people to sustain his tenure in office. But when the 22nd Amendment eliminated the prospect of re-election for a second-term president, it took much of the political discipline with it. I'm sure you all remember President Obama's whispered comment to Medvedev about Europe's missile defense systems. It's important for Vladimir to give me some space. This is my last election. After my election, I have more flexibility. So much for political discipline. Congress's first line of defense against a lawless president is the power of the purse. Madison, in Federalist Paper number 58, called this power the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people. But the passage of time has really proven this to be quite an overstatement. The notion that Congress can bring President Obama to heel by simply defunding the programs or activities that occasion his abuse is met with a number of practical difficulties. The first one is simply that he's abused his power so promiscuously that it frustrates any effort to remedy that abuse or those abuses by targeting specific programs and activities for defunding. But the second concern, and I think more difficult problem, is that federal programs are designed, at least in theory, to benefit directly American citizens, or otherwise to serve their interests. And defending a program necessarily makes the beneficiaries, defunding a program necessarily makes that program's beneficiaries essentially hostages in any congressional use of the purse to coerce the president. The third reality is that any effort to coerce President Obama by denying him certain funds for particular programs will only, in all likelihood, almost certainly provoke his abuse with respect to other funds. You probably recall that when President Obama unilaterally created his federal insurance exchange under Obamacare, he funded it with almost $500 million that he simply took from the so-called prevention fund. Now that was an act that even Democrats denounced as illegal. Which brings us to the nuclear option, impeachment. Well, impeachment, we've been hearing a lot of talk about impeachment lately. Well, that's a drastic remedy, mandating upon conviction in the Senate, removal from office. It's reserved, as Justice Joseph Story put it, for offenses which are committed by public men in violation of their public trust and duties. But the offense, or the pattern of offenses, must be grievous enough to warrant removal from office. And that, recall, requires a 2/3 majority vote to convict in the Senate. So impeachment has to be something for which there is broad political support within the country. The threshold question in any case of impeachment, of course, is whether here President Obama's serial violations of his oath of office satisfy the constitutional standard, which is, has he committed treason, bribery, or other high crimes and misdemeanors? Well, Andrew McCarthy has very recently published an excellent book. I think it's actually available outside in the corridor, called Faithless Execution, Building a Political Case for Obama's Impeachment. It makes a compelling case that President Obama has frequently and promiscuously committed impeachable offenses. Andrew McCarthy's judgment on this is really not surprising, but that view is apparently held by a variety of respected liberal constitutional scholars, including some very ardent supporters of this president. Consider this statement on the subject by a renowned liberal constitutional scholar. High crimes and misdemeanors, as terms of art, must refer to serious abuses of governmental power with which a public official has been entrusted. Certainly a president who ordered the government to stop enforcing the laws against marijuana because he was philosophically opposed to the regulation of marijuana, or because he was widely known to have used it as a youth and feared accusations of hypocrisy, would have committed an impeachable high crime or misdemeanor of the most dramatic sort by shredding his obligation to execute the laws of the country. Well, those are Professor Larry Tribe's words. Now, for the lawyers in the room, I won't have to explain it. He's among the most famous liberal constitutional professors, teaching at Harvard for many decades now, and was a mainstay defending liberal excesses throughout the last 40 years. He spoke these words actually in opposition to President Clinton's impeachment and the charge that Clinton's activities in connection with his private affairs, shall we say, were impeachable. Tribe argued that because President Clinton's offenses did not relate to his presidential responsibilities, they did not rise to the level of high crimes and misdemeanors. But President Obama's pattern of serious abuses of governmental power are precisely the kinds of offenses that Tribe says himself, correctly, that the impeachment clause was designed by the framers to remedy. To the same effect are the views of Professor Cass Sunstein. He's a former high official in the Obama White House, in the Office of Management and Budget there, and currently a professor also at Harvard Law School. He testified in the Clinton impeachment hearings that the ordinary predicate for impeachment is an act by the president that amounts to a large-scale abuse of distinctly presidential authority. For example, using the IRS to punish political opponents would constitute conduct that by itself raises serious questions about abuse of office. Raises serious questions. Look, surely no one will dispute that if the President Obama himself, was involved in any way in the IRS's now known abuses of its power for political reasons against political opponents, that the president would have committed an impeachable offense. After all, the second article of impeachment against Nixon included this charge. He has, acting personally and through his subordinates and agents, endeavored to cause, in violation of the constitutional rights of citizens, income tax audits or other income tax investigations to be initiated or conducted in a discriminatory manner. The argument against President Clinton's impeachment that was made by President Clinton himself is an indictment of President Obama. President Clinton's lawyers said this about the grounds for impeaching a president. Because impeachment of a president is a grave step for the nation, it is to be predicated only upon conduct seriously incompatible with the proper performance of constitutional duties of the president's office. Among the serious offenses against the system of government that the President Clinton's own lawyers cited as proper grounds for impeachment were these: conduct undermining the integrity of office, disregard of constitutional duties and the oath of office, arrogation of power, abuse of governmental processes. For President Obama, these things are just another day at the office. But again, the impeachment of the president is a grave step for the nation. Not only is its explicit purpose to legislatively overturn the sovereign judgment of the people at the ballot box, its impact on the work of the government and on our domestic tranquility could not be more deeply corrosive. But those costs, even though they are extraordinarily high, are costs that must nonetheless be paid if that is what is necessary to protect our Constitution and the rule of law. For if we don't have those things, we have nothing. We have nothing. Nothing separates us from the rest of the world, from the thugs. There is another option to impeachment, though, that I believe needs to be considered. It allows us to indict the president's unconstitutional conduct in office. The House of Representatives can, and I believe it should, prepare a unicameral resolution of censure condemning President Obama's usurpations of legislative authority and his refusal to faithfully execute the law. The Congressional Research Service has identified a number of historical precedents in which the Senate or the House adopted a resolution of censure or disapproval of a president or some other executive or judicial officer. In 1998, in fact, Senator Dianne Feinstein and 37 co-sponsors introduced a joint resolution in the Senate that recounted President Clinton's various misdeeds and, quote, condemned his wrongful conduct in the strongest term, and also censured the president himself personally and by name. Likewise, Representative Nancy Pelosi and other Democratic members of the House at that time proposed similar resolutions declaring that President Clinton, quote, fully deserves the censure and condemnation of the American people and the Congress. Strong words, words that would resonate throughout history. Adoption of a resolution of censure of this kind would allow the House to denounce President Obama's violations of his Article II responsibilities without detonating the I-bomb and all the implications of that portends. But it is critical that the historical record of our present constitutional crisis offer no support to future generations to the argument that the constitutional validity of President Obama's conduct in office can be judged by the fact that it was met with Congress's silence and thus its acquiescence. The great Senator Henry Clay, offering a Senate resolution denouncing as unconstitutional President Andrew Jackson's acts relating to the Bank of the United States, warned his fellow senators with these words: "The premonitory symptoms of despotism are upon us, and if Congress does not apply an instantaneous and effective remedy, the fatal collapse will soon come on, and we shall die, ignobly die, base, mean, and abject slaves, with the scorn and contempt of mankind, unpitied, unwept, and unmourned." Where are Henry Clay's? Such a resolution would also serve as a warning, a sort of constitutional yellow card, that Congress and the American people will not tolerate abuses of power indefinitely, and that henceforth the president acts at his peril. Again, nothing short of our constitutional order is at stake at this time in history. And the one thing that Congress and we must not do is do nothing. Thank you very much, ladies and gentlemen, for having me. I think we have a few moments for questions, please.
I'd like to ask one right away that I don't think you covered, that has been a bugaboo to me for a long time. You're talking about the abuses of the president, which I totally agree with and understand. But isn't it true also that the way that Congress has written some of these laws, like Obamacare, leaving so much leeway to the bureaucracy and to the way that they want to interpret it, a big part of this problem?
Make no mistake that Congress has enabled enormous abuses of power, and it has essentially shoveled its own legislative power into the hands of the so-called independent agencies, themselves, in my opinion, a constitutional violation of the separation of powers. Agencies that have no real accountability to the American people through direct responsibility to the president. And yes, Congress, you know, the FCC is authorized to regulate communications in the interests of the public. That's the limit of its charge. So it is clearly a delegation of legislative powers that can't be squared with the separation of powers. Congress is guilty of that, make no mistake. And I'm not here to defend by any stretch that. But you know, my focus at the moment, anyway, and I assure you, many of my litigations seek to they seek to remedy that precise kind of constitutional violation. But right now, I think our crisis focuses on the White House.
Thank you. I oftentimes refer to that as legislative malpractice in terms of the amount of power that our legislative branches have given to the regulatory agencies. My question for you is to what extent do you believe that the House lawsuit can or will be successful against President Obama?
I don't really want to handicap it. I will say that I understand its motivation. I understand the frustration that brings it forward, really, by the members of the House, and I hope that it succeeds. I think it's got some, you know, serious obstacles to overcome to success. One of the main ones, I mentioned earlier, the Line Item Veto Act. I don't know if you remember any of that at all, but Congress enacted a statute that gave President Clinton the power to literally item veto portions of a law. it struck me when I was advising President Reagan that he couldn't do that consistent with the Constitution, that this was clearly unconstitutional. The Congress couldn't even allow a president to do that, authorize a president to do that. I actually went to work for Democratic members of the House and Senate, along with some co-counsel, in challenging the constitutionality of that act. They brought that act, these members of Congress, and we knew that our biggest obstacle there would be standing, congressional standing, to bring an action in court against a law passed by Congress. And we lost that case, Raines against Byrd. Supreme Court held no, congressmen, members of Congress can't bring forward an action simply because it offends their own legislative power. There's got to be an injury of some different kind, is what the Supreme Court held. I think that's a big obstacle to this case. I hope they overcome it. We'll have to see. The denouement of the Line Item Veto Act is that the first time President Clinton enacted one of these item vetoes, he chose the wrong target. He canceled out $2 billion of Medicaid reimbursement to the city of New York, which at the time was run by Rudy Giuliani. And he called me up and said, Chuck, have I got standing? I think so, Mr. Mayor, I think so. And the Supreme Court ultimately agreed with Rudy Giuliani and Chuck Cooper that it is unconstitutional, and they struck it down.
Two-part question. One, are the NLRB decisions now considered null and void? And second part, if Republicans take over the Senate and maintain their majority in the House, my fear is that Obama may be writing more executive orders and maybe even going as far as martial law, something that extreme. What are your thoughts?
Yeah. Well, on the first question, whether those appointments which were struck down, whether the acts that were undertaken by the pseudo officers, the non-officers who were exercising that power at the time, I do not believe those are valid acts. I do not believe that when those officers were later confirmed by the Senate, as you know they were, through a complicated legislative agreement that took place, I do not believe that their subsequent ratification of their earlier acts somehow made them legitimize them. So my answer is no. And I'm litigating that very question right now with respect to NLRB decisions that were made during the period when it was in the control of these recess appointees. I don't know what we can expect in the days ahead in furtherance of this pattern that we have seen over these last many years of, as I say, serial offenses against the president's oath of office. I tremble when I think of what lies ahead. The things we have heard thus far at this Freedom Conference, the things we heard from Dr. Carson last night, we should be motivated by what this administration is capable of doing, and don't doubt that it's capable of even worse.
Sir, back here.
Yes.
I want to thank you for addressing an issue that's been on my mind, and I suspect on the minds of most of the other folks in this room for many months now. I would offer to you that I don't believe that a resolution of condemnation by the House or the Senate, I think that would bounce off President Obama like water off of a duck's back.
Yeah.
I also think...
I agree with that.
As the lady said, there's a possibility that we may take the Republicans may take the Senate, which would be a good thing, but we will not have 2/3. My question that I'd like you to comment on is, doesn't this condemn this great nation of ours to be living under a quasi-despotic regime for 2 years that will do things daily, weekly, and monthly without any idea of slowing it down?
So long as we don't have 2/3 to convict in the Senate, the answer to that is yes. It condemns us for 2 more years. And that, in a way, is also the genius of the founders, the genius of our democracy, and ultimately the ultimate protections of our freedom. We have to do everything that we can in the interim to minimize the damage to the body politic, to the rule of law, to our constitutional structures and order between now and then. And the one thing that, as I say, I don't think we can do until there is two-thirds political strength at that broad, deep level. The one thing that I do believe we must do, notwithstanding our shared agreement, yes, President Obama will not snap to attention by a resolution, even a joint resolution, if we should take the Senate, and that should become possible. To snap to attention and obey his constitutional limitations. It is important for a reason that will long outlive us in this moment in time. It's important that the record not be silent in the face of this.
One thing that you didn't mention, I know you said you didn't name everything he had done, but one
That
thing,
was only a concession to the shortness of life,
right?
and I did not mention it.
But one thing that
Whatever it
appears-
is.
One thing that I may be wrong, maybe he had the power to do this, but what about the exchange of 5 high-level terrorists for Bergdahl? You did not mention that, and I think that affects us nationally, especially with ISIS and so forth on the move.
Look, the truth is I didn't, that is among many things I didn't mention. There's a bill of particulars in the national security area that is long and powerful. I do commend Andrew McCarthy's book to you. He does go through in a very detailed fashion just really everything that could possibly be arguably considered an impeachable offense. And I think he lists numbers of things there that would not rise to that level of a high crime or misdemeanor. But certainly many of them in the national security area. And that extraordinary default on his responsibilities of office as commander-in-chief is among them.
Would you please comment on the IRS scandal and any potential paths to justice there that we may see?
Yeah. Well, I think the biggest, the immediate obstacle is really getting fully to the truth of it. Getting fully to the truth. This is among the evidences of this administration's real abuse of its powers. This is the commitment made early on to be the most transparent presidency in history, the most ethical presidency in history, has really crumbled openly as this administration does everything it can to prevent transparency, to prevent the truth from coming forward, for the American people to judge for themselves how they should react. I think, again, that episode, I called it one of the most appalling. I think it is an appalling abuse of presidential, or let me just say, of executive branch power. We don't know how high it went yet. And so I'm not going to presume where it may have gone. But in the fullness of time, the truth will come forward. We will know the truth. I'm confident of that. It will very possibly be too late to act upon it in any kind of structural, systematic way. But it won't be too late to act with respect to the particular individuals involved.
I think we have one more question.
Sir, what can be done about Harry Reid blocking all the legislation in the Senate? Do we have to just wait till hopefully the Republicans can take over the Senate, or is there something that can be done in the interim?
The only thing that can be done on that score is elect members to the Senate who will not vote to return him as majority leader. That's it. So we have a few months to go, and if the American people still love their country, still cherish their freedoms, are still devoted to their Constitution, at least that problem will soon go away. Thank you so much.